you define it? Can you help us define federalism?
Well, it's a funny thing to define federalism because it is something that defines the constitutional system, and yet people disagree as to whether it is a practical policy or an underlying principle. What is clear is that when we first formed the union that became the United States, it was based on state sovereignty. In fact, Article 2 of the Articles of Confederation made very clear that the states would be true sovereigns. That obviously proved to be something of a disaster as states exercised powers that are usually associated with nations, including power over trade and even printing their own currency. So that had to be changed, and what changed is that the states were no longer considered sovereigns in the technical sense. But you did have the reaffirmation that we had a limited government, and by limited it meant that the power would rest in the people and secondarily in the states.
A hard and fast definition of federalism would be something like the in-between between a unitary or national system on the one hand and a confederal system on the other. Now that sounds like that it would be a government that has some but not too much power, which is essentially true. In the American system, essentially what it means is a division of power that the people have given two different levels of government.
What is federalism? It is the division of power within a polity. The roots of the term are from the Latin word fidus, meaning covenant or contract. So it always had this history of the relationship of governmental entities one to another.
It's a great question to ask, what do we mean when we talk about a federal system? And if you approach this in the way that I think James Madison would have done it, you want to start with a preliminary definition, but then you have to look at specific cases in order to know what a federal system really looks like. So I would start by saying that federalism is a system of government which effectively divides the sovereign powers of ruling between two levels of government. Some sovereign powers, let's say, take obvious cases, war and diplomacy, will belong at the national level. Other sovereign powers will probably vest within the states or provinces or whatever you want to call the smaller, lesser units. In the 18th century, you would have said these involve matters of what was then called internal police. So I think that's the simplest way to think about it. I think the key thing here is to recognize that federal systems in many ways destroy the whole concept of sovereignty. We hold on to the word. The word has a kind of hallowed history of its own. We like to talk about sovereignty. We like to say that the states are sovereign, the national government is sovereign. But I think the reality is federalism, and particularly American federalism, really messes that up. It takes a bunch of particular powers, each of which could be characterized as an aspect of sovereignty, and it divides them or it allocates them to different levels of government. So the original concept of sovereignty, that there should be some absolute, final, ultimate, irresistible source of authority within a state, that really disappears in lots of ways. And to make sense of how a federal system operates, you have to start by looking very specifically at what the division of powers is.
Madison talked in the Federalist Papers about there being a double security to the rights of the people, because we're dividing powers between the national government and the states, and we're dividing powers among the federal government between the legislative, the judicial, and the executive. And if you look even closer at that, you can see federalism within, not only among, these various parts of the Constitution.
Usually what a constitution does is it determines which power is sovereign in a country. And so in a unitary state, the sovereign government, the one that has ultimate authority, is the national government. In a confederation, the sovereign governments are the governments of the component unit states, or whatever they're called. In a federal system, there's no one single government that is sovereign over all things. There's a division of labor, a division of responsibility. And in that sense, the people are sovereign. They decide where they want to distribute the power between the federal government or national government and the state or component units.
There are a lot of definitions of federalism in the academic literature, in kind of popular culture, and I think it's more useful to take a broad definition and then just try to be specific about the system you're talking about. So I would say a federal system is a system that divides power between two or more levels of government. It's, for a lot of definitions, important that that division be at least somewhat entrenched as a matter of constitutional law so that it's not easy to change by ordinary legislation. Some people define federalism as requiring some sort of umpire to decide disputes between the constituent units about the boundaries of power, so a court of some kind, but I'm not sure that's a necessary requirement. It's important to recognize that there's a lot of different ways to do federal systems. So we have our system that we've had for a long time. The Canadians have theirs, the Germans have theirs. India has a federal system, maybe the largest federal system in the world probably. The EU in Europe is arguably a federal system. There's a lot of debate among theorists about whether it really counts as a federal system, but I think it has the important elements of having two or more levels of government that divide power among them. So I think all these are federal systems.
The basic meaning of federalism is the constitutional division of authority between the state and federal governments, and more particularly, the American system of federalism is quite unusual in the world in that it involves a counterintuitive idea that both the states and the national government have a kind of sovereign power, or a limited kind of sovereign power. The idea of limited sovereign power is itself unusual. To divide up sovereign power between two governments is doubly unusual. If you look at the ideas of sovereignty throughout history. But the American idea of federalism is basically there's one ultimate sovereign, that's the people. The people delegate their part of their sovereignty to two governments, the federal government, the national government, and the state governments. The purpose of this system, the overall purpose of this complex division of authority is to set up a political competition between the two levels of government for a number of reasons, but the basic reason is to try to keep each government within its assigned roles through political competition.
Most federal systems in the world are calculated to bring together or harmonize or different political identities that differ by race or religion or ethnicity. Iraq is an example, a dramatic example, but there are other examples. Spain, the Catalan problem, Canada to our north, that's an example of that type of federalism. Switzerland is a very prominent example, 4 different languages in a single country. American federalism is unique because it's never had that. It was from the get-go, from the beginning, from the founding, about states' interests and citizens' interests. And that's a huge, huge difference between American federalism and any other federalism in the world. Federalism means that there's some range of activities over which states are actually autonomous and the federal government cannot tell them what to do. So the be-all and end-all of American federalism in that sense is the rule that the federal government may not commandeer state officials and tell them to do anything at all. It can incentivize them to do it by giving them money, or it can say, look, we'll give you a choice between either regulating on your own or we will do it for you, but it can never step in and say, you must now do this. And unitary systems, even very decentralized systems, can do that.
It was, in fact, the Constitution that reaffirmed that the power would rest with the people. And I think that people misunderstand that. Many academics misunderstand it. Some say, well, you know, the change from the Articles of Confederation to the Constitution meant that there was an abandonment of state sovereignty. I don't believe that's true. And many others will argue that the fact that people like James Madison referred to power resting with the people meant it didn't rest with the state. That is also, in my view, untrue. I think where the truth is found is that the Constitution views the state as the vehicle of the power exercised by the public. It is where the public expresses its views and also corrects the powers of the government. Rights are most protected, they're most safe when they're held closest. And by that it means they're held by the states. People have much more direct involvement in their state governments than they do in the federal government.
I think that the part of federalism that is underneath these temporary, sort of expedient positions is that just about everybody believes that government should be limited. They differ about how it should be limited, but at least in the United States we have a long history of recognizing that unlimited government at least has the risk of tyranny.
In the American system, the fundamental principles of federalism are based on the idea that this is the authority that the people have given the national government, and then the remaining authority is reserved to the states or to the people respectively, which is exactly, of course, what the 10th Amendment says. And the reason for this is because in a large territory, the national government can't do everything, and if it tries to, it becomes tyrannical. So it's incredibly important that the states retain the authority over things like police powers, health, welfare, education.
Decentralization is certainly a principle of federalism that both the left and the right can accept, and as a matter of fact do accept.
The concept of a limited federal government, unfortunately that's a principle that has almost been honored in the breach. From the very beginning, we were uneasy about a federal centralized system. And even people like Madison, who believed that we needed to recognize, correctly so, greater power in the federal government, they did so by carefully delineating, enumerating those powers.
The American system is a system of limited government. To the extent that federalism serves that purpose, and it does serve that purpose, people differ about how each government should be limited, but on the basic concept that governments need to be limited, and they need to be limited by competition because ambition has to check ambition, as the framers said. I think there's widespread agreement across the political spectrum on that.
The United States is different in how we structured our system. We don't have a confederation system, we don't have a unified system, and we don't actually have a sovereign system in the sense that the United States shattered the concept of sovereignty. We don't have this single all-powerful sovereign on the state or federal level. And that's because we viewed the sovereign as the people. That's a radically different idea, and people often brush over it. We have a system in which the states are left with all those powers not given to the federal government for two reasons. One is it's the ultimate protection of liberty. Rights are most protected, they're most safe when they're held closest. And by that it means they're held by the states. People have much more direct involvement in their state governments than they do in the federal government. So our federal system rests on this, you can call it quasi-sovereignty of the states. The states are really exercising the people's power.
In the United States Constitution, the people give power to the government. The government does not give rights to the people. This is entirely different than the British system of government, which is the reverse. And that's why, for example, in the Magna Carta, you see King John signing something. He's giving something over to the people. That could never happen in America, or let me say, I hope that never happens in America, because we are based on a system of enumerated powers. Why? Because it's the people who are sovereign, not the government.
The fundamental principles of federalism would have to be that there were certain spheres of power that one government had and another government didn't. The big argument of conservatives and liberals historically, or between Federalists and Anti-Federalists, or Whigs and Democrats, or whoever, were exactly what are the limits of those spheres. As John Marshall put it, that the power of the federal government, what we today call the federal government, the national government, are limited by the Constitution, but within that sphere they are supreme. And that was Marshall's great defense of the national government in its limited sphere. Jackson and Tawney sort of changed the emphasis and talked instead about the powers, the sovereign powers of the states, the police powers, that they were immune from federal encroachment. So it's a matter of where the line or division of powers is between these two governments.
Liberals and conservatives, they talk past one another, they disagree about their conceptions of federalism in important ways. In some very key ways, though, they talk about federalism in the same way, and there's common ground. Most important, I would say, would be Tocquevillian understandings of federalism. That's a touchstone on which liberals, conservatives, people of all stripes can oftentimes see an advantage for federalism. That is, Tocqueville, when he comes to America, writes Democracy in America. He writes extensively about the virtues of the American federal system as a school for democracy, an opportunity for learning the Republican traits of citizenship. He says, how else are you going to learn to participate in self-governance other than on a local scale where you can rule and be ruled, where you can have the opportunity for give and take, the opportunity for compromise? That's simply not possible in a unitary system to the same degree that it is when you have thriving local and state governments.
I think, yes, most certainly. There are some principles of federalism. The idea, for example, that by letting people do it themselves, you strengthen their character, you strengthen their skills, they get to practice the arts of taking care of themselves. And therefore, it's a good idea to decentralize privileges, it's a good idea to decentralize responsibilities, where decentralizing decisions will get you where you want to go, where it will actually work to strengthen people's character, where it will actually work to ameliorate some of the problems that causes you to consider centralizing in the first place.
The American constitutional system is based on checks and balances and other structural guarantees, but particularly the separation of powers and federalism are the core structural guarantees within our system. I don't think it is political, and I believe that down that road lies incredible instability and danger. I think it's structural. Much of my work has looked at the concept of structure and form. Often we talk about constitutional structure, but we rarely talk about the meaning of structure. I think that people like James Madison believe strongly that the structure of government influenced conduct. It was a behavioralistic model. You know, in architecture, particularly modern architects, define space and structure as a way of directing behavior, of getting people to operate, to move in certain ways. Constitutional structure is the same way. By cabining certain areas, we influence how they react to each other. I believe the most important touchstone of American federalism is the concept of states being allowed to experiment, to go their own way. It's one of the great strengths of the United States. While other governments sought a unified system so that you spoke with a single voice, the United States went a different direction. We wanted a chorus of voices. We wanted experimentation. That meant that states would go different ways. And you know, it's funny that de Tocqueville often said that the United States is an odd place because it seems to go in so many different directions, yet it seems to go from A to B faster than any other country. The reason is that we have a system that encourages creativity. It has a certain kinetic energy associated with all these different systems trying to come up with their own solutions. And we see that today with medical marijuana and suicide and other questions that divide states. This concept of a garden where 50 different states can bloom really goes to the heart of the United States. After all, federalism isn't about income tax, and it's certainly not about the direct election of senators. It's about these very basic concepts of the protection of liberty, to guarantee state experimentation, and to control the growth of the federal government. None of that has changed. And if anything, I think modern history shows the brilliance of those that wanted those principles to be protected. The federal government has done great good, there's no question about it. It has been there in critical moments. But I'm not too sure that the rise of the federal government, pound for pound, is worth what we have lost.
It's very hard to make sense of American constitutional development if we don't pay a lot of attention to what the framers of the Constitution were thinking, and what I think in particular James Madison was up to.
When the United States was falling apart under the Articles of Confederation, a number of the founders, particularly Madison, actually went and did his homework, and he researched for months ancient and modern confederacies, trying to find out what were their strengths and what were their weaknesses, because he knew a unitary kind of government, a consolidated kind of government, would lead to despotism. On the other hand, he knew that we needed to be a republic in a large territory, even an empire. Madison imagined us being really a very large country, possibly sea to shining sea. And to do that, he knew we had to be broken down into states. Otherwise, the people would not be able to govern themselves.
If you look at the founding period itself, when Madison in the Federalist Papers uses the term federal, it was equivalent to or the same as synonymous with confederal, which meant a government where the states were sovereign and the national government had no independent power. And before the Federalists changed the meaning of that term, that was the only alternative. Either you had a unitary government or the parts were sovereign. There was no sharing, there was no compound. Madison and the Federalists gave a new definition to federalism as something new, something unprecedented, this compound republic where you had a government that was neither fully one nor fully the other.
We have a system that Madison foresaw not just as a tripart branch system, but Madison actually often talked about the system in Newtonian terms, that he was fascinated by Newton. And he talked about the branches much in the same way as we talk about planets caught in an orbit. He created a system in which they would be locked by their countermeasures, their counter-ambitions in a fixed orbit.
You know, it's important to note that Madison was an active political thinker, that he was actively engaged in politics from 1775, 1776 for the next 40 years down to his retirement from the presidency, and then he had almost 20 years in retirement to reflect on American politics. And he was a very empirical thinker. It wasn't just that he was a smart guy who'd read a lot of books. He was actively engaged in decision-making. He was actively engaged in political activity. He helped to form a government, but then he also helped to form the first opposition party within that government. And he was open to new data. He was an empirical thinker.
Why is federalism important to Madison, and why do we need to remember it today? Madison said that for free government to work, we need to have a large territory. We need to have a United States, not one state, but 13 or maybe eventually, say, 50 states or more. And the idea would be that in that way we could control majority faction so that the majority could rule but not trample on the rights of the minority. For that to be effective, we need to have divisions of authority and power and dispersal of power. And that's important because for the people to check the government, they have to be able to form and communicate and organize their voice in such a way that it's heard.
Even though many claim that James Madison was a great supporter of the federal government, he wrote extensively about the danger of an all-powerful executive branch, an all-powerful president. But both federalism and separation of powers has this underlying purpose to avoid the concentration of power.
Madison talked in the Federalist Papers about there being a double security to the rights of the people. The compound republic idea is that certain parts of the government are going to deal with national questions and international questions. That would be what today we call the federal government. Foreign affairs, commerce among the states, those sorts of things that the states and localities can't deal with very effectively. But most of the ordinary affairs of life, of agriculture, of manufacturing, family issues, education, health, welfare, what came to be called legally the police powers, those are going to be left to the states. This wasn't a unitary government where you had one government that was responsible for everything, and it wasn't a confederate government where the national government didn't have any sovereign powers, but it was, as Madison said, neither one nor the other, but a compound of both of them.
It's really worth asking the question, is there not so much what would Madison think about A, B, or C, but was there a Madisonian way of thinking about problems? I think there was a Madisonian way of thinking about federalism. He says it a couple points in his correspondence. When you look at the American federal system, he says it was a real nondescript. If we use the word nondescript, we mean it in kind of a disparaging way. Madison gave it a more literal meaning. What he meant was there was no adequate antecedent or precedent for the American federal system. It was a genuine novelty. And there are a couple of different ways in which you could think about how that system would work. So one thing that concerned Madison was he lives long enough to see the evolution of this kind of simple-minded argument about the nature of the federal system. And in a lot of ways it's an argument about what was the original source of the Union? Is it the we the people, the preamble? Was there an American people out there creating a government de novo and therefore justifying or authorizing a powerful national government? Or was it really still we the states? And the states being the prior sovereign entities, they can never fully renounce their original sovereignty. And that's an idea that pulls in some ways on the Virginia and Kentucky resolutions of 1798, which had affirmed the idea of a compact among the states. The problem with those positions, I think Madison understood, was those were absolutist positions. It was either one or the other. It's kind of a binary mode of reasoning. So I think for Madison, the challenge of doing federalism, you could only make the system work if you were patient enough to try to puzzle it out. And so that required a good faith effort from both sides. You had to go into it in the spirit of accommodation. Not confrontation, but accommodation. You had to show a kind of patience and a kind of willingness to kind of work the problems out, I think in a sense on a case-by-case, issue-by-issue basis. Now, I think that's not a bad way. I'm essentially a historian of the 18th century, but I think I know something about how the government operates today. That's not a bad way to think about American federalism today.
Well, I do think Madison matters to us today. I think he matters to us today because he tried to think through the questions of free government, of constitutional government, not only for himself and his generation, but as he said, for posterity. He tried to create a government that could last through the ages. And one of the most important parts of that kind of government was the idea of federalism.
If you go article by article through the Constitution, every part of the Constitution has a federal aspect to it.
The specific relationships are multiple and complex, and they are treated in detail in the Constitution, but there is a broader sort of set of principles embedded in the constitutional text. Those broader principles, I think, have to do with the fundamental idea that both the states and the national government have assigned roles under our Constitution.
Often we talk about constitutional structure, but we rarely talk about the meaning of structure. I think that people like James Madison believe strongly that the structure of government influenced conduct. It was a behavioralistic model. You know, in architecture, particularly modern architects, define space and structure as a way of directing behavior, of getting people to operate, to move in certain ways. Constitutional structure is the same way. By cabining certain areas, we influence how they react to each other. The American constitutional system is based on checks and balances and other structural guarantees, but particularly the separation of powers and federalism are the core structural guarantees within our system.
In Article 1, the division of power between the Congress and the states through the enumeration of powers in Article 1, Section 8. The implication being that if the power isn't granted to Congress in Article 1, Section 8, and if it's not withheld from the states in Article 1, Section 10, our assumption is Congress doesn't have the power unless it's explicitly granted, and the states do have the power unless it's explicitly withheld. That's not airtight because there are parts of the Constitution that withhold powers from the Congress, but that was the basic understanding of the way that enumerated powers works. And the Bill of Rights and the 10th Amendment simply reiterate that as further making more explicit limitations on the power of the national government. James Madison made the argument, and Hamilton did especially in Federalist 84, that a Bill of Rights was not necessary because it would be making exceptions to powers that Congress doesn't have in the first place. And they had to give up on that argument because the popular demand, the Anti-Federalists, for a Bill of Rights was so great. Madison especially felt obliged to offer some amendments that would quell some of the concerns about this. The 10th Amendment is, in some sense, a reiteration of the whole theory of the structure of the Constitution.
The 10th Amendment is a reminder in the Constitution of the very nature of the American Social Compact. And the nature of the American Social Compact is essentially this: the people are sovereign. Why are the people sovereign? Because all men are created equal. And because all men are created equal, no man has the right to rule another man, except with his consent. And therefore, consent of the governed is necessary to the just powers of government.
We've become a more centralized system as a result of the amendments. The 13th, 14th, and 15th Amendments, which were adopted in the aftermath of the Civil War, gave more power to the national government to protect rights, right to vote, equality rights, and the ban on slavery. The 16th Amendment is likewise very important. The 16th Amendment is an amendment establishing the federal income tax, or allowing government, Congress to establish a federal income tax. And that provided resources to the federal government. Before, more funds were raised by the states and localities. Now the main revenue raiser is the federal government, and it can use the funds that it's raised, distribute them back to states and localities, but do so with, as it were, strings attached. And we will give you money to do particular things that we think are important.
If the question is which amendments are most important for creating a certain governmental structure, in particular for giving expression to the concept of federalism, I think the first amendment that you would have to mention is the 10th Amendment, which says that all powers not delegated to the United States are reserved to the states or the people. It's odd that this is such a fundamental expression of federalism, because in a way, it's, as the Supreme Court has said a number of times, it's a truism or a tautology, because to say if the federal government doesn't have it, it doesn't have it, and the power resides somewhere else, seems too obvious to be stated. But in fact, it's an exceedingly important principle because it's a direct affirmation of the principle that the federal government, the national government's legislative powers are limited.
Now, you might ask the question, has federalism always had the same meaning? There's a distinction that's sometimes used in political theory and constitutional law. Ronald Dworkin, the late legal philosopher, liked between a concept and a conception. We can have a general concept of federalism, but then there are many particular conceptions of how it operates. So I'm a historian, so if I think about federalism, I'd start with some initial definition. How do you divide power, as I said before, between two levels of government? I think there's a whole bunch of sovereign powers, and you allocate them across levels of government. But over time, for any of a number of reasons, that allocation may evolve, it may shift in modest incremental ways, or it may shift in fairly radical ways. In American history, for example, one would want to say that the Civil War amendments, particularly the adoption of the 14th Amendment, marked a radical break in the nature of American federalism because it gave the national government a constitutional basis for intervening in affairs within the states to protect due process, equal protection, the privileged immunities of citizens. But we certainly say at the end of the 19th century, the nature of American federalism also began to evolve because we start to get the makings of an administrative state. Independent regulatory commissions were established to deal with problems that different groups of Americans felt had to be dealt with. I think we certainly say that the development of the use of the funding power after the adoption of the income tax, but also after the expansion of federal power in the 20th century, gave the national government a very powerful weapon to get states to pursue policies that had been agreed upon in one way or another, whether in Congress or by different parts of the executive branch in Washington. We could have many conceptions of federalism as a historical problem. And in fact, that's what you would expect would happen.
The single most important amendment is an amendment that was created by the Supreme Court and was not adopted as an amendment, and that is the nationalization of the Bill of Rights. Remember, the Bill of Rights starts out saying, Congress shall make no law, and the Bill of Rights applies only to the Congress. But the court has amended the Constitution and applied the Bill of Rights despite the plain language that says only Congress, and is silent on the states. The real amendment that speaks to this is probably the amendment that provides for the direct election of the senators.
Maybe the most important factor is the one that's most difficult to pinpoint because it's about ideas that people had about the state and about government. in the 19th century. After the Civil War especially, you had a generation of American scholars. They're going to come to be called the progressives. In new institutions, American institutions of higher education especially, the modern research university and the modern law school, who are the first generation to think that the founders' constitutional devices were outdated and no longer applied. That the facts of modern life, the industrial and the urban revolutions, meant that an 18th century constitution was no longer adequate to the needs of the 19th and the 20th centuries. The most prominent of these thinkers would be Woodrow Wilson, who wrote a study on what he called congressional government, analyzing the problems of the founders' constitution in 1885. He wrote the first essay on the administrative state, on the science of administration in 1887. And then had a long academic career and then a political career. So Wilson was one of the most important people bringing these mostly European and mostly continental ideas. They were associated especially with French and German, originally Prussian, political thought and trying to apply them to American political problems. And of course, Wilson was very aware that some people would be alarmed that these European despotic institutions, Prussia was not the model of democracy and popular government, it was the model of bureaucracy. And Wilson wanted to assure the American people that America could have Prussian efficiency without Prussian autocracy, and that we could import these European ideas, but Americanize them and make them fit the American situation. This got into the law schools especially through new legal theories such as sociological jurisprudence. The idea that the founders' idea of natural law and natural rights they were fine for the 18th century in those circumstances, but they're no longer adequate. Ideas like liberty and equality, liberty of contract, were fine when you had a basically equal and agrarian society where you had face-to-face economic relations. But when you have giant corporations like U.S. Steel and an impoverished proletariat, as we do in the American industrial workforce, those principles no longer apply. So legal thought needed to grow as American society changed. Our political thought, our political institutions needed to change and adapt to changing circumstances. The analogy that Wilson drew was that, the founders' political thought was basically Newtonian. It was based upon the scientific conceit of the 18th century that Isaac Newton's physics, his mechanical view, could be applied to government. And Wilson said, but today's science is Darwinian. We now understand that government isn't a machine, it's a living organism. And organisms need to be integrated, not to have their powers checked and balanced against one another. They need to grow, otherwise they'll die. They need to adapt to their circumstances or they'll become extinct. So you have a new metaphor to political and legal thought.
Different people have different understandings of what the Constitution was meant to accomplish. They have different ways of approaching the interpretation of the document, original understanding, a more living Constitution approach. And they also, even if the principles are agreed upon, there may be questions regarding the application of the principles to a particular situation. Let me give you an example. Congress is given the power to regulate commerce among the several states. That was a relatively modest grant of power in the late 18th century because most of our commerce was not among the several states. Most of our commerce was purely intrastate. And now, of course, our economy has shifted dramatically, and as more commerce has become interstate, the scope of the powers of Congress have increased, not because the Constitution's changed, but because the economy has changed.
For a large part of our history, from the late 1890s until roughly 1935, 1936, the federal courts were saying that Congress's basic responsibility under the Commerce Clause. The Commerce Clause says Congress shall have the power to regulate commerce among the several states. States' rights federalists were saying, let's interpret that narrowly. Let's say that the basic responsibility of Congress under the Commerce Clause is to regulate interstate traffic, traffic that crossed state lines. But if an economic transaction took place entirely within a state, or if an economic practice took place entirely within a state, then that belonged to the states. So what that did was, for example, it gave the national government power to regulate the lengths of interstate railroad trains, the speed that they could travel, the other safety regulations applicable to interstate railroad trains, and even the rates that they could charge was left up to the federal government. But the working conditions of the railroad workers, even though they worked on interstate trains, they signed the labor contract within one jurisdiction, within one state. That was off limits to federal power. So the national government could regulate some of the country's economic life, but the state governments regulated other aspects of the country's economic life.
If the commerce power couldn't do it, the taxing power could do it. So Congress took phosphorus matches, which were very dangerous, especially in their manufacture, and taxed them out of existence, and the Supreme Court was willing to accept this. Narcotics also, the first controls of narcotics in American history were fees that physicians had to pay in order to prescribe our narcotics. There was nothing about raising revenue because the fees were so nominal, but it was a way of criminalizing the non-payment of these taxes. And some of them were simply interest groups that wanted to get Congress to use the taxing power to run their competitors out of business. When oleomargarine was invented as a substitute for butter, dairy farmers got organized and they petitioned Congress to levy prohibitive taxes on the manufacture of oleo. They later did this to other products, filled milk and other dairy products. The dairy lobby was very powerful in Congress. So eventually the taxing power came to be accepted as a way of regulating what would ordinarily be things that were left to the states. The biggest one of all was the so-called spending power. Congress can tax, and then what does it do with the money, especially after the 16th Amendment, especially after Congress has a large source of revenue. And it's interesting because there is no spending power per se in the Constitution. So what Congress can spend its money on seems to be without limit. And members of Congress, in cahoots with members of state legislatures, came up with schemes by which the federal government would provide usually 50% of the funds if the states agreed to undertake some project. First it was forest fire prevention, then it was maternal health, road building, vocational education, all sorts of things where Congress would establish the basic guidelines and provide the money, and the states would actually administer it. One of the things that this did was it sort of hid from public view the fact that you were building up a federal administrative state because the states were the ones doing the administration. If you look at the number of civilian employees in the federal government in the 20th century, it doesn't change all that much after the New Deal because usually the federal government is getting the states to provide the personnel and to carry out these activities. These were challenged in the 1920s, and the Supreme Court upheld them, saying that neither individual taxpayers nor states had standing to sue against these inducements, these blandishments, these carrots that the federal government was holding out. Most recently in 2012, for the first time, the Supreme Court said that there were limits to the strings that the federal government could attach to federal subsidies, to the so-called spending power in the NFIB versus Sibelius case. So that does open up a new route by which some federal powers could be challenged, but it remains to be seen how that pans out.
I'm not too sure the principles of federalism have changed over time, but I do think we have changed. American citizens have changed in very significant ways. They feel more detached from their government. They feel less relevant. And in some ways, they no longer view themselves as a type of moving part within the government machinery. All of that bodes rather badly for a system that directed power to remain in their hands. Governmental power is a lot like a gas in a closed space. If you increase the space, the gas will increase to fill it. The same is true with the federal government. If you increase the space for the federal government, it will naturally fill what space you give it. It's very hard to go back. There's plenty of cases in history where people have given up powers, and very few have they ever gotten them back, particularly when you've fixed interest in the exercise of power. So what has changed is social, certainly to some extent. The framers never anticipated that our government would be this large in terms of the federal government, but more importantly that it would play such a significant role socially. The federal government now delivers services to a degree that I think the framers would have not imagined. People have become reliant on the federal government. The result is that federalism seems like a quaint concept. What's dangerous about that is it's a protection of individual liberty. So the degree to which people become passive about the increasing power of federal government, they can watch the greatest protection of their individual liberty simply dissipate. And I think that's what we're seeing. As we see the rise of the federal government, the rise of the administrative state. There is a fascinating debate about the role of the Supreme Court on federalism. In fairness to the critics of federalism, we have had changes in the constitutional system. In 1913, you had the ratification of the 16th and 17th Amendments. They had a profound impact upon states' rights. One was the direct election of senators, and the other one was the creation of federal income tax. What's fascinating about those two amendments is that there was very little discussion at the time of the impact on federalism. They were being ratified for compelling reasons of their own. But their impact was devastating for the states because not only would they no longer effectively control the makeup of the U.S. Senate, the federal government would have its own source of revenue that it could manipulate and increase. Those two changes had this profound impact. So the question then becomes, in light of those changes, how active should the Supreme Court be in protecting federalism? Some justices, like Justice Ginsburg, have said it's really all political. You made the changes to the Constitution as the American public. You can essentially throw the bums out if you think they're eroding states' rights, but that it's not the job of the Supreme Court to preserve this balance that was changed so significantly. I take a different view. Federalism still remains a defining principle of the U.S. Constitution. Those amendments were not ratified as rejection of federalism. I think what it demands is for the Supreme Court to be more active in preserving the powers of the state. I think it is a healthy system to allow states to experiment. It's a healthy system to allow states to look very different. You know, we live at a time when uniformity is valued. We go to Starbucks and McDonald's because we know what we'll find there. We love predictability because our lives are so fast-moving. But stability and uniformity are not good things necessarily in government, because in government it means that we speak with a single voice even when we have many different voices that want to be heard.
I think that the legal challenges now play out against sort of two broad trends in American politics. One of them at the federal level and one of them at the state level. At the federal level, the overwhelming tendency, which is now becoming troublesome to many people's minds, including my own mind, is the migration of federal power from the Congress to the executive. For all sorts of reasons, from political polarization to a lot of different factors, Congress has been immobilized. It either legislates not at all, or it enacts these hyper-complicated statutes, and either way, it will have to give, or has given, the executive enormous discretion in pursuing these programs as it sees fit. So all the migration of power has been from the Congress to the executive. As a result of that, federalism is now shaped more by the executive than by anything Congress does. At the state level development is the emergence, or re-emergence, I should say, of sectional politics. Big differences among states. Those used to be cultural and break out over things like homosexual marriage or abortion, things like that. That's still very vibrant in many areas, but it's also economically true. So We have a lot of states that want to be really left alone and do their own thing and want to compete with other states and attract productive citizens. Texas, Oklahoma, Utah, the Dakotas, and those are the most productive and fastest growing states in the country. And you have other states, a block of other states that pursue a very different model. If you want to put a label on it, it's much more akin to a European welfare state. Big transfer payments, very, very expensive public programs. And those states, New York, California, Illinois, and so forth, are really locked into these programs. The cases that come up and reach the Supreme Court and the District of Columbia Circuit really reflect that. Many of them now concern sort of very, very arcane points of administrative law. They're not big constitutional cases for the most part. How far does your power reach? But did you have to give us notice about this program? Is it within the executive's power to undertake these programs, or do you really need a statute to govern you? Can you do this under the existing statutory authority, or do you need a new statute? And those kinds of questions crop up in a vast range of fields, from health insurance and healthcare to energy policy, the environment, education, welfare. That's where all the action is, and that's what I expect more of that in years ahead. The cases are very hard to explain to people who don't study this for a living, but they're nonetheless hugely important.
The state bureaucracy is a terribly important site of conflict over federalism issues. Think about the No Child Left Behind Act, for instance, where there are a lot of pretty extensive federal requirements imposed on state and local policymakers in education. And this is an area where the states had taken a primary role, still take a primary role for hundreds of years. And so there was a lot of pushback against some of these requirements, both I think from a sense that you're telling us what to do too much, and also from just a practical standpoint that these are unworkable requirements. We can't run the tests this way. And because the national government was dependent on the states to cooperate and implement these mandates, they had to listen to those state bureaucrats when they said, this sort of testing isn't going to work. And in fact, the Department of Education had to revisit a lot of the rules that they had formulated and roll them back a little bit. I think you see that in a lot of different areas. So I think people don't pay near enough attention to what happens after a federal law gets passed. You can pass a federal law, you can challenge it, maybe you succeed, maybe you don't. But even if the federal law purports to regulate some important area of policy, there's still going to be a lot of contestation about exactly what shape it takes. And so I think we need to be aware that federalism is going to come into play in those areas.
People wonder whether the Rehnquist Court's federalism revival is going to continue, or what's happened to it, or what will happen to it in the future. The revival itself was a set of cases where the court sought to readjust the relative levels of power and to restrain the national government to a greater extent than it had been at least since 1937. There are many people who expect that this revival, while it's been fairly quiet in the last 10 years or so, is just lying there waiting to reemerge. I myself think that the court's record over centuries is that it only episodically and partially protects a state authority under our federal system. It's disinclined to do so for a number of reasons, at least disinclined to do so consistently and in really operationally important ways. It is, after all, an arm of the national government itself.
Part of the danger that we have today is that people are becoming increasingly detached from their local governments. They feel increasingly set adrift in the political system. This generation's a generation that believes they really have very little influence over politics. That's an exceedingly dangerous thing. This whole concept of power resting with the citizens means nothing. if citizens don't exercise it.